111 times. One sentence. That's everything America got out of yesterday's hearing. Professor Kowalski is at the desk with us today to help us work through what actually happened in that room. Here's the part that stops people. He's already been pardoned. So why would he still need the fifth at all?
Start with the room. Senate Homeland Security, 3 hours, Rand Paul in the chair.
Today we go deeper into the mechanics of that refusal, because the law underneath it is genuinely unsettled.
111 refusals. That isn't a man ducking one hard question. That's a decision he walked in with.
3 hours. Call it 10,800 seconds. Spread across 111 refusals. That's one about every.
Elena, say that number again. Slowly.
One about every 100 seconds. For 3 straight hours. This fight didn't start yesterday either. Look at the two of them 5 years ago.
July 2021. Different committee, same fight about the same research.
5 years, still nothing settled.
Now the pardon. President Biden pardoned him in January of 2025, and that date matters more than anything else on this desk today. Professor Kowalski, does a pardon simply cancel the Fifth Amendment?
Not simply no. A pardon removes the risk of prosecution for the acts it covers, and the Supreme Court said so in Brown versus Walker back in 1896. Once you're pardoned, you stand as though the offense had never been committed, but a pardon has an edge, and the edge is a date.
So federal conduct tied to his COVID rules from 2014 up to January 19th is covered. That's the reading. I mean, the reading if the scope holds up.
That's the reading, yes. And nothing he said yesterday under oath sits inside it. New testimony is new conduct. That's the whole knot. If a witness lies under oath today, the pardon doesn't reach today. Perjury after a pardon is still perjury, and it's still prosecutable.
Split it, protected on the past, exposed on the new sworn testimony, that part.
Article the 7th, on the original parchment. That's the clause we now call the 5th. No person shall be compelled in any criminal case to be a witness against himself. Invoking it proves nothing on its own. Silence isn't guilt. That's not a technicality, that's the point of the clause.
Legally, that's right. Practically, it isn't the whole picture. A congressional hearing is not a criminal trial, and people watching one are perfectly free to draw negative inferences from a refusal. Professor Gerhardt at North Carolina made exactly that point yesterday.
Both things are true then. He's within his rights, and it still looks bad.
Before we crown that a dodge, Erica, his lawyers had a reason.
There's a reason his lawyers were worried. Rand Paul subpoenaed him in June, then released more than 1,000 pages of his private diary days before the hearing.
1,000 pages, dropped days out. Fauci called that an attempt to embarrass and intimidate him. Fenrir, that reason has a name. Professor Macklin at Florida put it flatter than anyone. You know what looks worse than taking the fifth? A perjury trial.
The other side of the desk sees it completely differently. Senator Hawley told him straight out that he has no Fifth Amendment rights left because he's been pardoned.
And it's only fair to say the other half out loud. Fauci has denied that accusation for years, and his own attorney says the privilege here is valid. 2 readings, side by side. One says the pardon erased the risk, and that's Brown versus Walker talking, but it ignores the new testimony. The other says perjury is not pardoned, state charges survive a federal one, and yes, it still reads as hiding.
Both have real support, but no court has squarely decided it. And Burdick, 1915, only helps a witness who refuses the pardon, so it isn't this. A federal pardon also doesn't touch state charges, a long shot here, though Florida's Attorney General has said he's looking, and the privilege survives anywhere a government could still realistically prosecute.
Untested means nobody knows, including the people voting on it.
Even Paul concedes that. He called it a novel legal question the courts may have to decide. The next real date is August 5th, when the committee votes on holding him in contempt of Congress.
August 5th. If it passes, it's either civil enforcement or a criminal referral to the Justice Department.
Here's where I land, and I'll say it plainly. Both sides are arguing something real, and neither one is obviously right yet. The pardon genuinely weakens the claim for the old conduct. The perjury exposure genuinely keeps it alive for the new. That's not a loophole. That's an unsettled question. And it gets settled in a courtroom, not a hearing room. So watch August 5th and plan from there. Professor Kowalski, thank you. That dateline you drew that the pardon stops on January 19th is the piece most people are missing. 10 seconds.
The date does the work.
If this made a loud story make sense, hit like and subscribe. That's the whole job here. If you were his lawyer on August 5th, would you let him talk? We'll be here when the vote lands. Until then, read past the headline.